Good afternoon, everybody. Thank you for attending today's training on fair housing. Just a couple reminders before we get started. Please keep your microphones and your cameras off during the presentation to avoid distractions. Also, if you have questions, please type them in the chat box and I will relay them to our presenter as we go along. Lastly, if you need a certificate of participation, please email Stacey at the end of today's presentation, and she will get one sent out to you. Also, there will be a short survey sent out after today's presentation. If you could please take a few minutes to fill that out and provide any feedback and possible topics you would like to hear, that would be greatly appreciated. So with that, I will turn it over to Kirsten.
All right, thanks, Kylie. I'm Kirsten Small. I am with the North Dakota Department of Labor and Human Rights, and I am going to give you guys kind of a rundown of a lot of the state and federal regulations related to fair housing. I know there's nothing more exciting than sitting through a 2-hour training. On top of that, having it be a training solely about laws, regulations, and usually things that people do wrong. So hopefully we'll make it a little bit, at least a little bit entertaining, at least something that's a little engaging, and hopefully everybody will walk away with some additional knowledge on fair housing, kind of what to watch for, things to look out for to prevent issues in the future, and kind of explain a little bit more about what our department does. So to begin with, kind of what we're going to go through today, we're going to first and foremost explain a little bit about what the department does. So before I worked for the department, I'll be honest, I did not really know what the Department of Labor and Human Rights entirely handled. So I'll give you some insight into what exactly it is that we handle, how our department runs, and some of the issues that we deal with. We'll talk about what is housing discrimination. We'll talk about the fair housing laws that pertain to our specific department, as well as we'll look at the federal and the state regulations that we look at when we're evaluating whether or not violations of the law occurred. We'll go through some of just the statistics and facts, give you a little bit of an overview of what it is that our department sees in a given year. So what kind of discrimination issues that our state usually deals with, what kind of issues are frequently happening. We'll talk about a few common issues, so common complaint types or common issues that we see at the department related to discrimination. And then we'll walk through some best practices. So some things just as an investigator, as an employee of the department, some of the things that we see that hopefully can prevent some of those future issues from occurring. So again, what does our department do? Obviously, from the title, we kind of understand we handle the wage and hour type complaints and human rights complaints. So the Department of Labor is the wage and hour side of things, and then the human rights side of things is more related to the discrimination. But technically speaking, we are broken down into kind of base pillars that our department handles. So obviously we have the wage and hour division. We have the human rights division, which like I said, is related to the discrimination side of things. And then one thing that we also have outreach and education and awareness. So basically these type of presentations. So whether it be to do trainings, provide booths or brochures to the public, or just even if you call in and ask questions, we can provide you some information and education as to what our department handles. We are a very small agency. I think that was probably the most surprising thing. I've been with the department a little over 8 years now. And when I first came to the department, I just assumed Department of Labor, it's a big department. They handle a lot of complaints each year. Currently, we have 5 investigators, we have 2 administrative staff, and then we have a commissioner and a human rights director. So extremely small department. Of those, all the complaints that we receive, whether they're related to wage and hour division or the human rights side of things, those 5 investigators are who handle and look into any of those complaints. So very small department. We really handle quite a broad range of issues. The Department of Labor technically started as part of the Department of Agriculture, then it kind of grew into the Department of Labor, and then eventually the human rights side of things was introduced and added to it. And so now that's kind of the base of what we handle. Is really, we see probably the brunt of it is the wage and hour division, and then the discrimination side of things is our kind of next major pillar. So when we talk about the Human Rights Division, there's a couple main pieces of the laws that we handle related to human rights. So we handle the Human Rights Act. This is going to be a lot of the general provisions related to discrimination in employment, discrimination in public service and public accommodation, and credit transactions. The North Dakota Housing Discrimination Act, this is going to be the state side of things that just handles solely the housing discrimination issue. So any discriminatory acts related to housing, whether it's rental or sale, and it's going to be the brunt of what we're talking about today. We also have 2 retaliation statutes that we also handle related to that Human Rights Division. One is the whistleblower law. So this is coverage for employees who report some sort of law violation, and as a result, the employer takes some sort of retaliatory action against them. And then lastly, this North Dakota Public Employee Relations Act. That one's going to be a very limited claim base, and basically it's solely related to employees, public employees who report some sort of alleged legal violation in writing to either an agency head, like an attorney general's office, or basically to a direct report. Those are related to that North Dakota Employee Relations Act, similar to the Whistleblower Act, but a little bit more defined coverage related to that. So really briefly, the wage and hour side of things, this is, again, one of probably the brunt of what we see as far as claims filed and issues that we deal with the department. And these are related to, quite simply, wage and hour complaints. So whether it be wages for work performed, if issues with hours or non-payment of wages, it can handle paid time off, break times, deductions from pay, any kind of issues related to your pay is really the main piece of that. But we also handle any employees that are 14 and 15 years old in the state. They have to be certified basically with a youth employment certificate to work. We issue those certificates out, and we also monitor any sort of work conditions for underage employees. We also handle independent contractor verifications, sub-minimum wage issues, and then employment agency licensing. So we do handle a number of different issues related to the wage and hour. And you'll see here when we go forward into looking at the human rights side of things, again, the wage and hour is where we see the brunt of our complaints. So we've had about 5,800 public contacts, and this is everything from a telephone call to an email, or even just an individual walking in with questions. So about 5,800 public contacts, and this was for the last biennium, the 2019 through 2021 biennium. We had 639 claims filed and 689 claims closed, just solely on the wage and hour side of things. Going into a little bit more about what will be pertinent and relevant to what we're talking about today is the human rights side of things. Again, this is any of the coverages related to discrimination. So it includes employment discrimination, public service or public accommodation. And what that means is basically if an individual walks in, for example, to Walmart, they believe that they've been discriminated against, they can file with our department, and that would be a public accommodation case. Let's say they are receiving services from the city water department, and they believe that they've been discriminated against in their services or treatment, then they can file a public service complaint. So those are related not necessarily to employment issues, but discrimination in some sort of kind of public venue, whether it be just a general business or an actual public service. The next one is credit transaction. Credit transaction, we do not see a ton with at the department for various reasons. Honestly, I don't know if everyone always knows that we handle credit transaction discrimination, but sometimes it can overlap occasionally into things like housing discrimination, because credit transaction discrimination would be if you were denied services, or if you were, for example, you went into a bank to receive a loan and you believe that the treatment that you had received was discriminatory. So they did not either approve you for a proper amount based on one of your protected categories, or you felt that they were discriminatory in the way that they handled the transaction. That could be considered a credit transaction discrimination issue. So they are issues we do handle in our department. We just don't see a lot of claims filed on that basis. And then the last one's housing discrimination, which again, we will absolutely be talking about the most today, in specific talking about what housing discrimination is, what kind of coverages our law provides for, and what some of those common issues that we see related to housing discrimination. So again, for wage and hour, we had about 5,833 public contacts. And so on the human rights side of things, as you can tell, it's substantially lower. And that could be for a variety of reasons. It could be everything from the fact that, employees or individuals may not either believe that they have been discriminated against, maybe they're not sure who to necessarily contact. And sometimes it can be something as small as like a pride thing, or if they feel that they can prove their case, because it's a little easier or a little more black and white oftentimes in a wage and hour complaint, where you say, I didn't receive my paycheck. Here's the proof I was supposed to receive it. I didn't get it. It's a lot harder to prove things like discrimination cases. So that could be a part of the reason why it's hard to tell, but we do see a substantial less contacts related to human rights as well as complaints filed. So of the last biennium, we have about 1,700 public contacts and 459 claims filed, 474 claims closed. Again, of these, this is any kind of discrimination. So employment discrimination, public service, public accommodation, and housing. So what exactly is housing discrimination? Obviously, when it comes to words like discrimination or harassment, there are dictionary definitions of it, and there are legal definitions. So under the law, the legal definition of housing discrimination is treating someone differently in the sale or rental of housing because of the person's membership in a protected category. And we'll talk a little bit more about what that membership in a protected category is. But basically, even under the law, even when people don't necessarily mean to discriminate, it doesn't necessarily mean that there's no violation that can be found, because even if you had good intentions, your actions or what you state could technically be discriminatory. And we'll talk a little bit more about what that means or what that looks like as we go forward. So there's two main laws that our department handles related to housing discrimination. The first one is the Fair Housing Act of 1968, often also called the FHA, and this is the federal law. So this is the actual federal piece of the law that HUD handles. We obviously still evaluate the law as well, but this is going to be the federal law that we're looking at. The other side of it is the North Dakota Housing Discrimination Act of 1999, and that one's the state law. So we'll talk a little bit when we talk about what the department's process is for handling complaints, but we do have a work sharing agreement with HUD, which means that we have we have the ability to investigate cases for them. They have the ability to investigate cases for us. And we do have to have what we call substantially equivalent laws. Basically, we can't have contradicting laws. So we can't have a law that says one thing that completely opposes what the federal law states about that same issue. Basically, instead of having two separate investigations going on at one time for one issue, the work sharing agreement allows us to be able to kind of work in conjunction, and instead of doubling up the efforts, be able to go through these issues. It's just whenever we have any of these cases, if it does fall under that state and the federal law, we look at both laws. So even though we are the state department, we still have the authority to look at what the federal law is and whether or not a violation occurred on that realm as well. When it comes to the findings, so once we go through the investigation and we make a determination, basically either side of things, so the federal side can adopt our findings and vice versa. And with this partnership, HUD does kind of have oversight as far as being able to review and kind of audit our cases, just to, again, make sure that we're all on the same page on how we're investigating these issues. So regardless of whether or not you're getting a case investigated directly by HUD or by our department, it's going to be a very, very similar process. So again, we know what housing discrimination is, but what exactly do the fair housing laws do? Basically, it's there to make it unlawful to treat someone differently in the sale or rental of housing because of the person's membership in a protected category. So basically to level the playing field, to make sure that regardless of what kind of housing transaction you have or the living situation that you're in, that you're being treated fairly regardless of what your protected category is. So regardless of kind of some of those aspects that you can't change personally, that you're still being treated fairly. So that's what the fair housing laws, that's why they were established, that's why they're maintained. It's to ensure equality in the sale or rental of housing. So we've said it a number of times, protected categories, the membership in a protected category. So what exactly are the protected categories? The protected categories under the Fair Housing Act, which again is the federal side of things, includes race, color, religion, sex, national origin, familial status, and disability. So all of these categories are all covered under the federal side of things, and these are the only bases that are the only protected categories that do apply on the federal side of things. There are additional bases that do apply in various states, including our own, which basically say, yep, we adhere to all of these federal guidelines, all these federal protected categories, but we'd like to include additional categories. We would like to ensure that there's equality for other protected bases aside from just what the federal guidelines require. So again, it's kind of the federal side of things is more of the baseline, and we can expand on that, which in our case, the state has done through various passing of different legislation over the years. So the state side of things, we have all of those same federal protected categories, so the race, color, religion, national origin, sex, familial status, and disability. But we also have additional protected categories of the receipt of public assistance, marital status, age, and then certain victims of domestic violence. With relation to the receipt of public assistance, this would be for individuals that may be receiving, for example, Section 8 housing vouchers, or maybe they're receiving North Dakota rent help. They're receiving some sort of public aid or assistance that allows them, and it doesn't necessarily have to only be rental assistance. It could be, for example, if they were receiving maybe food stamps or some kind of other public assistance that just because they're receiving it, the respondent is treating that individual differently because of it, they could file on that receipt of public assistance. Marital status, pretty self-explanatory. That could be, whether it's being discriminated against because they're single, maybe they're being discriminated against because they're divorced, or because they're married or widowed, perhaps. So regardless, whatever their marital status is, that they're being discriminated against based on that marital status. Age, this is not for any age. It is the age 40 years old and older. So it is a limited category. It's not just, I felt like I was being discriminated against because I was 22 and I was renting there. That doesn't apply because the individual is not in that protected class. The protected class is age 40 and older. And then lastly, the certain victims of domestic violence. This was a brand new category, actually was added, not this recent session, but the session before. And basically it provides for coverage for individuals that are in domestic violence situations where they're as part of some sort of state program and they can't be discriminated against based solely on that. It is a very limited category. I know under the Department of Human Services, they had a few additional provisions related to domestic violence and breaking leases due to a domestic violence situation and what kind of ramifications they can have related to that. But for our department's purposes and under the North Dakota Housing Discrimination Act, it is a very limited, and it basically worded that it only pertains to individuals that are part of a public program related to domestic violence. So very limited perspective on that. Thus far, since it's been enacted, we haven't had any cases that specifically have qualified to be filed under that basis because, again, it is pretty limited. So when we look at those, who or what is covered, when we have a complaint filed, what are some of the initial things that we're looking at? First and foremost, is the person who filed, are they a member of a protected category? So again, of those protected categories, does the complainant fall under one of those categories? Are they alleging discrimination under one of those categories? Those are kind of the first things that we're going to look at. If they don't fall under a protected category, like I said, with that age one, if the individual's 22, that person is not a member of a protected category because it doesn't fall within that age 40 or older. So that's kind of the first initial step that we look at, is whether or not that complainant is a member of a protected category. Next, we always look at, is a dwelling or housing related transaction covered under the law? So for the most part, a lot of what we see is related to sales or rentals. So we see, I would say, far exceeding on the rental side of things, whether that's maybe an issuing of a non-renewal or an eviction or a denial of rental, or maybe they're, not providing a reasonable accommodation in a rental situation. We see a lot under the rental side of things, but it does cover sales as well, and some other housing related transactions, as well as other kind of, I guess, exceptional situations. So things like maybe a temporary shelter could certainly fall under a housing related discrimination case. It's really very fact specific, and it's going to depend on the specific situation, but there are things that are outside of, well, hey, they aren't renting from us, they're not buying from us, so how could it apply? It can, depending on what the situation is. And then lastly, we also look at, is the respondent in themselves covered under the law? So we look at, are they exempt from some of the fair housing laws? Because there are some pieces that could certainly apply that would make it a little bit different as far as how they're covered under the law. So that brings us to, are there exemptions under the law? Long and short of it, yes, there are exemptions. There are certain sales or rentals that are exempt. Specifically, one of the main ones that we see or that would come up, it's called the Mrs. Murphy's exemption. And that is going to pertain to if there are 4 or fewer rental units and the owner lives in one of those units. So kind of just for simplistic explanation's sake, if there was a 4-plex and one of the owners lives in that unit and there's only the one 4-plex, that could fall under one of these exemptions. It could fall under the Mrs. Murphy's exemption, but one of the big things is it does have to be demonstrated that the owner themselves lives in one of those units. So just because, let's say, mom actually owns the building, she does the rental, but her son is the one who handles all of it. He's the one that's doing the day-to-day business. He is handling all of the rental applications, and he's the one that lives in the building. Technically speaking, they may not necessarily fall under that exemption because he may not be the true owner of the building or the owner of the rental property or maybe the property management group. So there are limitations on that, and we do look at it quite closely. So just because there's 4 units and you go, yep, see, the owner lives there, hands down, it's exempt. Make sure to really take a close look at that if you're going to claim one of those exemptions, because we obviously would be looking at some of those kind of nuances to see and make sure that it truly does fall under one of those exemptions. There are religious exemptions. So there are religious organizations, let's say they have maybe living quarters for specific individuals who are part of that religious organization, and only individuals of that same religion can live there. They can potentially be able to show that limitation or preference or demonstrate, yes, we only want individuals of this certain religion, but they cannot discriminate on the basis of race, color, or national origin. So even though they're exempt from a number of the fair housing laws, they still cannot discriminate based on that race, color, or national origin. Same with the private club exemption. Very similar as the religious exemption. Let's say you are maybe in a private, like a country club or a certain neighborhood that's a very private club that only members can be part of, and they are eliminating other people who apply because they are not part of that private club. They can do that, except for, again, they cannot discriminate based on that race, color, or national origin. So even though there's exemptions from the law, even those exemptions still have some parameters. And then lastly, the housing for elderly. We get this, fairly often of, well, what if it's a 55 and older community? Can they do that? Yes, they can. Most of the time for the elderly housing exemption, the only thing that it could provide an exemption from is the familial status and the age. For the most part, those are really the only 2 pieces that could be exempted from those fair housing laws. So there are some exceptions to the rule, some exemptions that basically state that they don't have to follow quite the same fair housing laws, but it doesn't mean that it's a complete free-for-all. There are still some limitations on what you can and can't do or say related to specifically an individual's protected category. So now we'll roll into a little bit of the statistics and facts. So we've kind of talked a little bit about what the department is and what we handle. We talked a little bit about what fair housing laws are, how they apply. But what is it that we actually see case-wise in North Dakota? Because again, we handle cases on the state side of things as well as the federal side of things. And depending on your different regions, you're going to see a lot of difference as far as the types of cases that are handled. But we'll talk a little bit about specifically in North Dakota, what kind of cases that we see. So in that last biennium, so that 2019 through 2021, we had a total of 48 claims that were filed. And of those 48 claims, we had 27 of them that resolved via conciliation. What that means is basically that the parties came to some sort of resolution between themselves and resolved it that way, as opposed to moving through the process. And we'll talk a little bit more in depth about what conciliation is. But instead of moving through the entirety of the investigation process, the parties came to some sort of resolution prior to that point. 13 of those were no reasonable cause, which means that we did the entirety of the investigation. And upon the conclusion of that investigation, we determined that although allegations were made that some sort of discriminatory action had occurred, that based on the facts and evidence that a violation of the law did not occur, or that we believe based on that facts and evidence that there is no evidence that a violation occurred. So we had 13 of those, no reasonable cause, which means that those would be a violation of the law did occur. Really, it kind of goes on an annual basis for the most part as to whether or not we have cause cases or not. We call them cause cases, which means that based on the facts and evidence, we do believe a violation of law occurred. Some years we don't have any, like we had in this situation, and others we have several in a given year. It really just depends on what cases we see come through, whether or not those cases conciliated or not. So just because you see a 0 here on reasonable cause does not mean we never find violations, but it is certainly, statistically speaking, more often than not that we do not find violations, just based on how the facts fell and what the situation was based on the law. But it doesn't mean we do not find violations occurring ever, because we certainly do. It just really, some of those can resolve prior to us issuing that determination, or again, just kind of fluctuates from year to year. One of those cases was dismissed. So if we, let's, for example, say we are unable to maintain contact with the individual, so the complainant we've tried to reach out to, we're unable to make contact with them, they have quit responding to our department, it could be dismissed. There are a few other situations where they might be dismissed, but really the biggest one that we see is if the claimant, for lack of better terms, falls off the face of the planet. So sometimes they can be dismissed that way. We do have the ability to refer cases to HUD. So whether we either don't have jurisdiction, or it's been requested to be sent to HUD, or HUD has requested us to send it to them for whatever reason, whether they're handling other cases of a similar type, or perhaps they have a couple of them from the similar respondent. Perhaps those might be reasons that they referred to HUD. We didn't have any of those in the last biennium. And we had 5 that were withdrawn with resolution and 2 that were withdrawn without resolution. Sometimes the parties just come to an agreement amongst themselves. They don't necessarily want to have an agreement through the department, or perhaps during the midst of us sending the complaints to the parties to actually kind of start that investigative process, they may have already come to a resolution amongst themselves. So if that's the case, sometimes the complainant just says, hey, we came to an agreement, I'd like to close the complaint. That would be withdrawing it with a resolution. Obviously, the alternative is withdrawn without resolution. If the individual says, I just don't want to move forward with this, I don't have time for this, haven't found a resolution yet, but I just don't want to move forward. This is an extra piece on my plate that I don't want to deal with. They can withdraw it for any reason if they want, whether they've come to a resolution with the respondent or not. Of these 48 claims that we had in this last biennium, it was down 10 from the previous biennium. But I would say probably on average, we have about 20 to 40 cases minimum that are filed really each year. It just depends. They ebb and flow. Sometimes we have more. Obviously, during kind of the oil boom and the subsequent time thereafter, we saw quite an influx. We did see a bit of an influx after COVID, when a lot of individuals were not necessarily they were having trouble in the housing situation, or they were being evicted and they believed it was discriminatory. So it kind of ebbs and flows depending on certain situations that are happening just kind of environmentally or with the current climate. So of those 48 cases, as you can see from the number breakdown, by far the most were filed on disability. As you kind of run through these numbers, it's a little off-putting because there's obviously more than the 48 claims. So this is because these issues can be filed on multiple bases. So for example, if an individual, let's say they called us and they said, I believe that I was evicted, and I think it was based on my race, my color, and my national origin. You could have 3 bases on one complaint. So when you see kind of the numbers skewed a little bit from the total complaints we had, there's a reason for it. It's because they oftentimes may have multiple bases. Oftentimes we'll see a complaint that's filed under one basis and then also filed on something like retaliation. So basically saying, I requested, for example, a reasonable accommodation due to my disability. And after I had requested that, the respondent was upset. They got mad at me and they decided to evict me. I think they evicted me because I requested that reasonable accommodation. So that could be a disability and retaliation complaint. Of the 28 disability complaints we had during this time period, 24 of them were accommodation complaints, which means that an individual had requested some sort of reasonable accommodation that they believe was denied. So we'll talk a little bit more in depth about disability, but when we're saying that disability is by far the most filed on items, still is, just because these are last biennium numbers, I can very much vouch and attest for this is still currently the trend. Disability is the most filed on item on the state side of things, as well as if you look up the federal statistics, it's the same thing. Disability discrimination, specifically in housing, is the most filed on item. When you look at these, one thing to keep in mind is, like I said, that some of these are going to be filed on multiple basis, but some of them, as you can see, we didn't have, for example, any during this period that were filed on the basis of religion. So just because there are certain protected categories, it's kind of hit or miss on whether or not they're filed on frequently. And again, if you were to go to other parts of the country, you would see this trend or these numbers skewed substantially more, because in other areas and regions of the country, they may have a substantial difference in, for example, race, color, national origin complaints, as opposed to maybe public assistance or marital status, which again is a state only. So we see a lot of fluctuation in the different regions depending on kind of what their breakdown is, what their just total makeup of their state is, and what some of those state protections are. So disability. When it comes to disability, it can be an extremely complicated assessment. A lot of individuals can state, I am a person with a disability, and they may be, depending on under what an evaluation they're looking at. So some may qualify for disability under, for example, SSDI. Maybe they're qualified as being a person with a disability because of their veteran status. The VA has assessed them. They believe that they have a disability rating. That is not necessarily what our department looks at when it comes to disability. So when it comes to disability related to the Fair Housing Act, the Century Code, it's really very specific to stating that the individual has to have one of these three things. So they either have to have a physical or mental impairment that substantially limits a major life activity. They have to have a record or a history of such impairment, or they have to be regarded as being an individual with such an impairment. Basically, we could do an entire training solely on disability and what that definition means, what some of those substantial limitations are, and what could or could not qualify as being a substantial limitation. But it is going to be an extremely fact-specific inquiry depending on the situation. A lot of times it can be things though that substantial major or substantially limiting in a major life activity that doesn't always just mean something that's extremely visible. It can be something as little as, for example, let's say you have diabetes. Your endocrine system is substantially limited in its major life activity, its ability to process insulin. And so that can be a substantial impairment, even though you may look at it and say, well, they can walk, they can do this, they can do that. Certain heart conditions, certain neurological conditions, certain mental conditions, whether it be anxiety or PTSD, it's not always going to be something that's extremely apparent. And so it really, really comes down to the specific facts of the situation. And each person oftentimes handles a substantially limits them in different ways. So this inquiry into whether or not they either have that physical and mental impairment, they have that record or history of the impairment, or whether or not they're regarded as, is going to really depend on the facts of the situation. When it comes to the individual being regarded as an individual, this is not, it's basically to protect individuals from stereotypes. It's not that the person necessarily actually has an impairment, but they're being treated or regarded as having such an impairment. So, for example, let's say an individual, maybe their family or their parents have a history of, for example, schizophrenia or some sort of major condition. And the landlord says, I know your parents have it. I'm pretty sure it runs in the family. And they believe that this individual has schizophrenia as well, even though they do not. That could be being regarded as being an individual. You don't necessarily have that condition. You don't have a record or have been diagnosed with such condition, but you're being treated as if you have been. So it can only be discrimination if the person has a disability. So the specific person who filed a complaint, they have a disability. That's the only person that can be covered, right? No, not necessarily. It can be treatment because of that person's disability. It could be treatment based on the person associated with that person. So let's say, my aunt came to visit and the landlord had been discriminatory towards her or was discriminating against her in some way because of her disability. I can be harmed or impacted based on that action, even though it wasn't against me, even though I don't have the specific disability. But if it's impacting the individual because of their association with that person and that protected category, so if their association with the person with a disability, that could be disability related discrimination. Again, even though the person doesn't have a disability, they're being impacted by that disability related discriminatory practice. Another piece of it could be, for example, discriminatory statements or things that are said showing some sort of preference based on disability, or things that are said that are illegal related to disability. You could have somebody who filed based on that. For example, if they have what they call testers, so individuals who, let's say they maybe call a landlord and say, hey, I have, 6 service animals and I want to see this certain unit. And the landlord goes, no, we don't allow service animals. That could be a discriminatory practice. Even though that person may not have a disability, they're being subjected to some sort of discriminatory act, and they're in that testing kind of capacity, and so they could file. So just because the person themselves doesn't have a disability doesn't mean that they can't necessarily file. So how does that affect you? Obviously, we go through kind of the legal definitions of all of this, but how does this affect you? Specifically, disability is the biggest one that we see. It's the biggest issue that we see. And the thing we see the most with it is reasonable accommodations. So there's kind of 2 prongs when it comes to disability related discrimination. Obviously, it can just be general disability related discrimination. So if I felt that I was being harassed due to my disability, I felt that I was being evicted due to my disability, those obviously can be applicable. But 2 major prongs that we see related to disability discrimination oftentimes is reasonable accommodation and reasonable modification. So reasonable accommodations is the requesting of a change, exception, or adjustment to a rule, policy, practice, or service. It can be really anything. Let's say an individual needs help moving their garbage to the garbage dumpster. That could be asking for an exception or an adjustment to whatever the rule, policy, practice, or service is. Maybe they ask for a closer parking space, or they requested an exemption to the no pets allowed policy due to an assistance animal. Those can all be reasonable accommodations because they're just modifications or adjustments to already existing rules, policies, practices. When we look at either one of the fair housing laws, whether it's the state law or the federal law, they do require reasonable accommodations for individuals with a disability, and failure to provide those reasonable accommodations can constitute a discrimination on the basis of disability. It's going to very much be on a case-by-case basis, and there are some exceptions to it. So there can be some reasons why a reasonable accommodation would be denied, but we look at that very much on a case-by-case basis. When it comes to reasonable accommodations, one of the big things is it does not have to be in writing on a specific form that's requested, and they don't have to use specific words. They don't have to have the magic words of saying, I'm requesting a reasonable accommodation because I am a person with a disability under the law, things like that. They don't have to have specific magic words to say so. Obviously, it can't be entirely ambiguous. You have to be demonstrating you're requesting some sort of reasonable accommodation, or demonstrating that you are indeed asking for some sort of change, exception, adjustment based on your disability.
Kristen,
It's
there's a question.
sure.
Could they limit the amount of service animals that could be in a rental unit? I'm asking as a lot of places have a number allowed or size allowed.
So I'll get into it a little bit more, but the short answer of it is no. You can't necessarily limit the number of service animals. The same goes with you can't necessarily limit the type of service animals. We have a whole service animal presentation coming up here in a few weeks, which I'll go in more depth about. But basically, as long as the individual or the tenant can prove or demonstrate that there's a medical related need for the service animal or animals, that's really all that has to be demonstrated. Because one big example could be, let's say they have 3 service animals, and the 3 service animals technically alleviate the different types of symptoms. So one service animal alleviates a certain symptom, this other one alleviates a different symptom, and there could be medical reasoning, or there could be kind of medical documentation indicating, yes, this person does need 3 service animals. Another example is if, let's say, the individual, their reasonable accommodation service animal is a ferret. Ferrets, apparently they do not do well living singular. They have to live in pairs. That's how they thrive. They do better if they're able to live with a partner, basically, or another ferret. And so there might be a reason why there would be another one. So having limitations on the number can be a very slippery slope, because just as there are exemptions to a no pets policy, just because you have a policy that says we only allow 1 service animal, there may be situations where there would have to be an exception to that rule if there was a medical need for more than 1. So kind of I would say the short answer, but that was kind of a long answer to the short answer. But technically speaking, no, you can't limit the amount of service animals, because it's really going to depend on the medical situation. So reasonable accommodations, most common filed on issue in our department and with HUD. Obviously, we see it a ton. It's going to be something that, as landlords, you guys will see it a ton. And it can be in many, many facets. Obviously, again, we kind of see service animals as being a frequent one, but it can be throughout the process. So it can be for your current tenants. It could be for prospective tenants. So it could be, for example, if an individual says, hey, I have a learning disability. I'm unable to complete this paperwork on my own. Can you help me fill out the application? That could be a reasonable accommodation request due to a disability, and the respondent may have to provide that accommodation. So it's not always just for your current tenants, it could be prospective tenants as well. Respondents should address requests in a timely manner. I completely understand it can be a frustrating process. At times, there may be you're requesting clarification and you're not getting it very quickly, or the individual is just bombarding you with request after request, or they're asking several times, maybe a day, about different things, or asking questions, or wondering where you're at with it. You still need to work towards responding to the requests. Even if it's saying, updating them, yep, we got your request, we're working through it, we have it out to our corporate office, we're just waiting for a response, that touch base every once in a while. You really do need to work through the requests in a timely manner. There's not like a set you have to respond within 5 days. You have to respond within 10 days, because it really is going to depend on the situation. If an individual is asking some sort of request that really requires you to go through a number of touch bases with different departments, maybe with state agencies, whatever the case may be, it may take some time, but as a landlord, you still have an obligation to touch base with them, let them know you are working towards it. You can't just get a request and just basically sit on it, either hoping it'll just kind of go away, or knowing, hey, I think we're going to get rid of this person anyway, so we really don't have to do anything. Just an untimely delay, or a delay or an untimely response in and of itself can be problematic. It can be viewed as denying the accommodation request if you fail to provide some sort of response. And the request obviously may impact the individual's residence. Oftentimes, it's going to impact their specific unit, but it could also impact other areas as well, common areas. It could be, if they are, for example, a service animal, the animal may be coming and going through the main hallways. It may be in the lobby area. Those are all things you're going to have to look at and address. And again, basically, the big thing about reasonable accommodation is eliminating any sort of barriers that are caused with relation to a disability in their enjoyments of the property. So just because you've granted an accommodation request, for example, for them to have, let's say, maybe a ground, or a service animal, that you've granted that request, and you said, but you can't ever bring it in the hallway. But there's some sort of, maybe there's all the mailboxes in the hallway, or there's the maybe all the memos are in the hallway, and that individual, for whatever reason, medically needs the service animal with them at all times. To limit them the ability to take the service animal out into the hallways could impact their ability to have the same enjoyments as other tenants just because of their disability. So those are things just to kind of keep in mind. Sometimes they may impact some of those common areas as well. It's not always necessarily going to solely be the individual's unit. And obviously we talk a lot, and we see commonly things like reasonable accommodation requests for service animals or assistance animals, but it can also be a number of other things. It can be things like parking spaces, or let's say the individual, there are no assigned parking spaces, but the individual, due to their mobility impairment, they've requested to have an assigned parking spot. That could be an exception to the rule or policy in providing them just an assigned parking spot, things like that. Those can be examples of reasonable accommodations. It could be that they're just asking to pay the rent in a different way. Let's say there's a drop box and you request that they always pay it in that drop box, and the individual says, due to my condition, I'm unable to walk to the drop box. Can I have my friend drop it off? Or can I mail it in to you? You know, whatever the case may be. It's an exception to some sort of policy or practice. The alternative to reasonable accommodations is reasonable modifications. These are similar to reasonable accommodations, but instead of being an alteration to, for example, a policy or a practice, it's going to be structural changes. Excuse me. It would be things like maybe widening doorways or making a ramp or installing grab bars. Those are all things that could be modification. Generally speaking, we're going to look at the same undue hardship test as far as, is it going to provide, in providing this reasonable modification, is it going to cause some sort of alteration to our business practice? Is it so unreasonable financially that we cannot provide that? Those are all things that may be looked at. The big differences between reasonable accommodations and modifications, obviously reasonable accommodations, those are those alterations. They're alterations or changes to various rules, policies, practices, or services. Oftentimes those are going to be paid by the landlord. So if there is any sort of cost associated with it, for the most part, that's going to be provided by the landlord. Whereas a modification is that removal of a physical barrier, and that's oftentimes going to be costs paid by the tenant. So if they, for example, needed grab bars, the tenant likely would have to pay for that unless there's certain federally supported programs. So if the building is federally supported in certain ways, they may have to pay for it. I always have one coughing attack during my presentations, inevitably. So I have my water and I still am dying slightly. So I think I'll get it out of my system here. Again, same with that reasonable modifications and the accommodations alike. They don't have to be in specific writing. They don't have to use specific magic words. They don't have to, again, specifically state to you, I'm a person with a disability under the Fair Housing Act and the North Dakota Housing Discrimination Act. I'm requesting a reasonable accommodation or a reasonable modification. They don't have to use any of those specific words. A lot of times if you work with a claimant, they're going to be willing to work with you on providing the information you need or clarifying what it is that they need. Not always, but they do not have to have it on a specific form. So if you state, you know, all right, you're requesting a reasonable accommodation, you have to fill out this form. Otherwise, we can't provide it. That may be problematic because you can't require them solely to provide it on that form, or you can't provide it. If you've been given notice of a request for a reasonable accommodation or modification, really the respondent has a duty to do something, whether it, you know, if you don't have enough information, you can certainly request more to get it clarified. But again, you can't require it solely to be provided on a specific form. So what's reasonable? Obviously, again, just like discrimination, just like harassment, reasonable within itself can have different meanings to different people. So what is it that we look at on whether or not it's reasonable is it has to demonstrate that it does not constitute some sort of undue hardship. So we look at, is it going to impose some sort of undue financial or administrative burden? And then we also look at, does not interfere with the business operation. So would making that accommodation or that modification require a fundamental alteration in the nature of how the provider provides operations? If either one of those answers of those questions is yes, then you still may be required to provide some alternative options, but it doesn't have to always be the option that the tenant is requesting specifically. It doesn't always have to be solely this is what I want. This is what you have to provide. If it truly is some sort of undue hardship or causes that interference with the business operations, you may be able to say no to that request, but you might have to look at other alternative options. When we look at whether or not it's reasonable, this is something that's argued out frequently when we have cases of, well, it was unreasonable. They wanted us to provide somebody to help bring their garbage to the dumpster because the garbage can lid was too heavy. We couldn't obviously hire somebody else. That was just unrealistic. But in looking at it, maybe there were a number of different options on either getting a different kind of garbage can, or maybe there was a maintenance employee who did frequent the building. They were there once a week during garbage day just to do the general garbage cans. You know, they'd have to prove that that was some sort of undue hardship, that it was unable to be provided in order to really demonstrate that unreasonable nature of it. It's something we look at extremely closely because sometimes when it's used as a defense, it's not always actually completely valid. There were other options, and sometimes there really weren't. Maybe there was truly an undue hardship that it was unable to provide any sort of modification or change in order to allow that individual whatever reasonable accommodation request that they were asking for. I will say it again as we go forward, but working with tenants can usually go a long way. Not always. I completely understand, you know, people are people, and you still may have complaints filed against you, but really working with your tenants, trying to understand from their perspective what it is that they're requesting, what it is that they're needing. All of those things can be very helpful in trying to find remedies or resolutions that will make both parties happy. For the most part, tenants, they may, at times, it may seem that they're being difficult, but a lot of times they do want to find a remedy. This is their home. This is the place that is their residence. And a lot of times that is something that's very important in maintaining, having, you know, the comfort of having a home, having that place to stay. So it's more often than not, I would definitely say that people really do want to try to work towards resolutions. And just briefly, we'll touch on service animals. I know this is always the danger zone hot topic that lots of people don't like. It's why I'm always so excited to provide a full service animal presentation here in a couple of weeks. Unfortunately, it's just a very touchy topic, understandably so. It seems that it kind of goes to both sides. Sometimes it's more favorable to claimants, sometimes it's more favorable to landlords. And currently, it just seems, especially with landlords, it seems like a very difficult hurdle to overcome. But it is there. It's going to be there for a while. So it's best to just know a little bit more about it. So we'll touch base on it a little bit more. Like I said, in a couple of weeks, we'll have a full service animals presentation and kind of walk through a little bit more detail on these things. So if this really sparks your interest, we'll see you in 2 weeks, and there's more to come on this, but it is always kind of a touchy subject just because it can be very polarizing and ambiguous. When it comes to service and assistance animals, individuals that are disabled may require the use of service and or assistance animals. Basically, it's the biggest reasonable accommodation request for the most part is just asking for an exemption to that no pets policy. So even though the unit itself may be, or the building itself may be a no pets building, they can ask for exceptions to that rule due to their disability. Again, when you look at it just kind of from the outset, all it is asking for an alteration to that policy, which is the definition of a reasonable accommodation request. So in order to deny that accommodation request, the landlord would have to prove that the accommodation, it's not reasonable, it's not necessary, or it causes that undue burden on the landlord, whether that's that financial or administrative, or alters that business practice. That those are things that we'd be looking at when it comes to whether or not it's a reasonable accommodation. It can be a variety of assistance animals. So it's not necessarily just cats and dogs. As I kind of mentioned before, it could be ferrets, it could be lizards, it could be turtles, it can be alligators. Just a couple weeks ago in Florida, there was an individual that was stating that they had an assistance animal that was an alligator. They can be those animals. It seems a little strange for some people, especially if, let's say, you have a phobia of some of those critters and you wonder how that could be something that would alleviate any sort of symptoms of a disability, but it can. When a lot of these disabilities, kind of the medical documentation that they've provided, it means that their service provider has evaluated them, has determined that this request, this individual's disability symptoms would be alleviated or assisted by whatever this animal is. So those are kind of, they can be a variety of different types of animals, not necessarily just cats or dogs. There are a couple of items as far as, and I'll talk a little bit about them later, but HUD does have a few joint statements. They have a joint statement with the Department of Justice. They just in 2020 issued out kind of some service animal, assistance animal guidance that was very helpful in just providing some questions and answers. But the joint statement that they had for 2004 with the Department of Justice basically states that housing providers may not require persons with a disability to pay extra fees or deposits as a condition of receiving a reasonable accommodation. Where this comes up the most is in service or assistance animals of paying some sort of pet deposit. You cannot require an individual with a disability that's requesting this reasonable accommodation to pay a fee or an extra fee or deposit as a condition of receiving that accommodation. The same would go, and the best way I think to kind of outward thinking of it is you wouldn't necessarily charge an individual an extra fee if they were in a wheelchair or if they had a walker because you had concerns they might cause damage to the unit. You can't charge them an extra fee. Sure, after it's all said and done, if there's, damage to the unit, you can certainly see what kind of ramifications you have for that or what kind of resources you can obtain as far as maybe pursuing the issues through court or seeking payment for any sort of the damage fees, but you can't request them to provide an upfront fee or deposit just solely because the animal will be in the unit. Because again, think of it as a reasonable accommodation or a kind of a disability related assistive device as opposed to a pet. They're not the same thing. An assistance animal is not a pet. Again, there's a couple guidance items on HUD's website. That one with the Department of Justice, they had one from 2013, but their recent one from 2020 is very helpful as well. And it talks a lot about service and assistance animals, gives a lot of information. Again, it can be polarizing. You may not necessarily love the information that it's providing, but it does provide the guidance as to when we look at any sort of disability related discrimination complaints, these are some of the pieces that we're looking at. We ourselves use a lot of these documents as guidance in these cases. Obviously, being that we have the state side of things and the federal side of things, and we're kind of that partnership, we have that work share agreement, we really evaluate the laws similar and the same as HUD does. So looking at that guidance can be helpful in understanding how the department looks at some of these situations or cases. Oh, lost my PowerPoint here. There we go. So some of the things that we have as defenses, oftentimes with service and assistance animals, is the direct threat defense. This could be that, well, I have concerns that this animal is dangerous. Certainly could absolutely be a valid concern, unless it is just based on a perception or a stereotype of, well, I know that German Shepherds can be very aggressive. I know that pit bulls or Rottweilers can be very aggressive. Unless there is actual demonstrable evidence that that specific animal provides for some sort of direct threat. It's not to say that you're just waiting for something to happen until you can do something, but if there is no evidence that there's any reason to be concerned about the animal, you can't just use the defense that we were concerned about that certain type of breed or that certain type of size of animal. HUD is very specific on outlining what kind of requirements you can and can't put on a service animal, and things like requiring certain breed types to be exempted, certain sizes or number of animals can be problematic if you have those set in place specifically related to service animals, because again, kind of looking at that exception to the rule situation, unless it's a direct threat, undue
I
burden,
don't.
unreasonable.
Okay, so they're all income based. So can I get your number and call you back because I am in a Zoom meeting right now?
The other thing that we see oftentimes is city restrictions, whether let's say the city themselves, we see a little bit less of this, but if the city themselves has a restriction on certain breeds, specifically is where we see it commonly. Just because the city has restrictions doesn't necessarily mean that you can just use that as a defense. For example, let's say they have a breed restriction within the city, and you say, well, see, the city says they can't have the certain kind of animal. The claimant may have a claim with the city if there's no provision, kind of an exception for service or assistance animals. They may be able to file against the city for having discriminatory practices in their policy of restricting certain animals, even though they're assistance or service animals. It doesn't necessarily mean that you can solely lean on that of saying, see, they have this exception, so that means we can as well, because it's not always that necessarily the city ordinance is within the parameters of the law either. So just solely basing it on that can be problematic depending on how the city policy is written. Again, common areas, it may apply to the common areas that the individual is requesting some sort of accommodation to have the animal in those common areas so that they can have the full enjoyments and benefits of the property. A lot of these things, I know you kind of want to come at us going, well, how is that reasonable, or how is that going to alleviate their disability related symptoms? Again, all of these things are so fact and case specific that it really is going to depend on what the medical documentation is stating, what the individual is requesting, what the business structure is, or how the building itself, how it works, how it's laid out. All of those things can certainly play into some of these pieces. So it's overwhelming, but these are all things that certainly come up in a lot of service or assistance animal cases that we see. Requirements of the animal to be either spayed and neutered, certain breed restrictions, weight limitations. Like I said, HUD has very specific guidance that those pieces and those parameters cannot be set in place for service or assistance animals. Again, it's going to be really fact specific on what you can and can have, but a lot of times when you have those very, I would say, just tight policies that provide for very little movement in there, that's when a lot of these type of issues may come up, because when you have those really tight parameters of saying, well, you can't have this, you can't have this, you can't have this, when there's those exceptions to the rule or those reasonable accommodations that are requested, it can be problematic to have such a tight and non-permissive policy. You can absolutely have expectations on behavior, whether that be expecting the tenant to clean up after the animal, expecting that the animal, maintain behavioral expectations, that they are not misbehaving, that they are not, barking constantly, that they're not attacking other people. You can certainly have expectations. It's not just a free-for-all because it is a service or assistance animal, but it is, again, you want to make sure that it's based on actual situations, not necessarily just on perceptions of what may or may not happen. So what if another tenant also has a disability, such as allergies, that won't allow the service animal to be in the unit? This is a question I have gotten frequently, and it is something that really is going to depend on a case-by-case basis. If you, as a landlord, let's say you have 100 units, you may have multiple reasonable accommodation requests at one time. You're going to have to look at each one of those reasonable accommodation requests and try to work with each one of them. It's not saying that you have to provide it for everyone and be equal and, only say yes to every reasonable accommodation request, but you really do have to work with each different request and try to find some sort of remedy. May not necessarily be the specific remedies that the tenant is requesting, but it has to be effective. So if there are, for example, one tenant has allergies, one tenant has an assistance animal, perhaps you may have to try to move the units around, or you may have to evaluate each one of their requests and see how you can either make both of them work or try to remedy what the requesters are requesting. So the way we kind of look at it is in a situation like that, it's almost like competing disabilities. And just because there's two requests doesn't mean you can just say absolutely no to one of them. You really have to evaluate each one kind of individually and also trying to make it work conjunctively. One big change that we had, again, not this last session, but the session before, was related to disability-related documentation for service and assistance animals. This specifically was a law that was put into effect trying to eliminate some of the internet documentation that can be provided. Internet documentation can be very much a slippery slope. It still has to be obviously demonstrated that the individual is a person with a disability and that the reasonable accommodation request that they're requesting is needed for their disability. But especially after COVID, this can be a lot more broad than it used to be. It's not that just because it is an internet provider does not necessarily mean that it's not a valid source of a reasonable accommodation request or documentation. So when it comes to these internet produced documents, if you have concerns with them, contacting an attorney that is well versed in housing related laws can be very helpful, because just because it's internet provided does not mean it's invalid. But this law basically is trying to reduce the amount of issues related to internet provided documents, and it specifically indicates that the documentation has to be reliable and it can't be just kind of a paid for service or something that you would just pay to receive the item. It has not, I would say kind of surprisingly, has not gone to court yet or gone to the Supreme Court, just to kind of get clarification on what that means as far as what reliable is. But at this time, really, it's just how it reads, exactly that way, of indicating it has to be reliable documentation. But one of the big things to always keep in mind is just making sure you are not the doctor. And so if you have documentation indicating the individual is a person with a disability, they are in need of the reasonable accommodation, for the most part, you have to work towards providing that reasonable accommodation, unless, again, you can prove some sort of non-reasonable, that it's not reasonable or that it's an undue burden in some way. Outside of that, you really have to work towards providing that accommodation. So can requests be denied? It sounds like I'm pretty much telling you absolutely not. Yes, they absolutely can be. There's obviously reasons why a request can be denied for various reasons, whether it be that the individual is not a person with a disability and you have documentation as such. If you're requesting documentation and the documentation is never provided, those can be problems, obviously. If the accommodation is not reasonable, if it does cause some sort of undue burden on the respondent, you absolutely can deny requests. It's just, it really has to be very much supported as the reasoning why you're denying it. It can't just be because you felt like it was a really bad request. You can't just deny a request without really kind of a good reason as to why you're denying it. So again, that undue hardship, that's a reason why you might deny a request. And so when you look at that again, does it impose some sort of undue financial or administrative burden, or does it change the way we do business? If either one of those questions is answered as yes, then it might be an ability to say no to that reasonable accommodation. Again, you still may have to provide some sort of accommodation, but it doesn't necessarily have to be that specific accommodation. Again, direct threat. Big thing to keep in mind with this is making sure you're not just making this assumption that you have a fear or a speculation or a stereotype specifically because, for example, one we see just most frequently is like a breed of animal that you're saying, well, that breed of dog tends to be problematic. You can't just make that assumption based on kind of that stereotype of a certain breed. You're going to want to look at the nature, duration, and severity of the risk of injury. You want to look at the actual probability that an injury will occur, and that whether or not there's any reasonable accommodation that might eliminate that direct threat. So those are all things that you'll want to keep in mind. So you basically want to make sure you're not just making it based on an assumption. You actually have some sort of substantial fact that actually makes you reason that this is a direct threat. So can the landlord ask for documentation if the individual requests a reasonable accommodation, they want to have some sort of alteration? Well, can I ask them for more documentation, for example, about their disability? Potentially. This is kind of a maybe answer, only because it really depends on what you're asking for and what the situation is. If you have been provided documentation that demonstrates the person is a person with a disability, demonstrates the need for the accommodation or the modification, and it shows that relationship between the person's disability and that need for the requested accommodation or modification, then no, you can't. That is what you can have is the information that demonstrates all of those things. Now, if any of that is absolutely unclear, if it's not showing that that there is no evidence that the person is a person with a disability, or it is not showing any of those things, or that you don't have any of the information at all, yes, you can ask for some sort of documentation if it is not a visible need and tie. So let's say the individual is requesting a ground floor unit in a building that has only stairs. They have no elevator. They have just a ramp into the main floor, and that's it. They're requesting an accommodation to move to the main floor unit. You really can't ask for additional documentation because it is visually apparent what their request is, how it's tied to their disability, and that it's likely necessary for their disability. So requesting additional documentation in that situation could be problematic. But if it's not readily apparent, it may be something that you may need additional information on. Again, big thing here is if you're provided the information that demonstrates those things, that yes, they are a person with a disability, yes, they need this accommodation or modification, and there's a tie between those two things, you are, again, not doctors. You can't make that call. Even if you are doctors, if you're provided that documentation, really, that's what you have to go off of as far as your documentation. You can't continuing to request additional just to prove that there is a need because you don't believe that there is necessarily a need can be problematic. That can actually be a violation depending on what information you had already been provided. So again, if the documentation received for the accommodation is not clear, you can ask for additional documentation that verifies the presence of a disability and or explains that specific connection. But just keep in mind, if you're not the doctor or the medical provider, if it makes that clear connection, really, unless it's an undue hardship or a direct threat, you generally have to provide that reasonable accommodation. So big things to keep in mind with reasonable accommodations and modifications, it's not always going to be this clear, concise statement or on that prescribed form. They're not always going to tell you, hey, I'm actually requesting a reasonable accommodation. Can you help me through this? Make sure whoever is handling any of these requests is able to either direct them to the person they should be speaking to or is trained on what they should be watching for. Because just because maybe the individual they talk to isn't the most well-versed in this kind of law, it doesn't necessarily mean that that's just an exemption from the law. Just an ignorance to what the laws were isn't necessarily defense. So anytime you have any individuals working with the public, making sure they're aware of what reasonable accommodations are, or some of those kind of just key things that might be stated. Hey, I'm asking for a change to this. Hey, that should be a red flag. I should start thinking about either who to direct them to talk about this. I should, make sure I'm listening for what they're requesting, those type of things, making sure you're just clear. You clearly understand that when a request is made, that you need to have some sort of action going forward. Respond promptly. Undue delays may be deemed as a failure to provide that accommodation. Nobody really likes to be left hanging. So if you can, keep in contact with them, try to work with them, try to move expeditiously on trying to find some sort of resolution to their request. Think about the dance theory with reasonableness. So looking at, are they a person with a disability? That's the D. A, the accommodation. So is the tenant requesting a change in some sort of rules or practice? Is the accommodation necessary? So is that accommodation or modification necessary for the full use and enjoyment of the property? Cost. Does the accommodation or modification impose some sort of undue financial or administrative cost? And then the effect. Would the accommodation or modification affect the fundamental change in the landlord's business? So all of those things you should keep in mind as far as kind of the back of your head when if you're going to say that it was unreasonable, those things have to be assessed and looked at. And as soon as you make a determination that a request is being made, make sure you're listening, making sure that you're taking notes and knowing where you're going to go with the next steps. Those are big things. Just common mistakes is when you request that they have to be on a certain form, or being too rigid or overburdensome with rules, having very overbroad, like I said, when you have such a tight policy that it's really hard to make any sort of exceptions to those rules. That can be problematic. A lot of times we see problems with failing to engage in that interactive process. So once they receive a reasonable accommodation request, they just kind of leave people hanging. That's usually a big problem that we see. Charging fees or deposits, for example, for pet deposits, having some sort of requiring medical documentation kind of in an overburdensome way of saying, well, you provided all these things, let me ask for more, so kind of trying to make it a burdensome process. All of those things are common issues that we see related to accommodations and modifications. Another big thing that we see, this is the second most filed on item, is retaliation. Retaliation is kind of the natural response. Oftentimes it's a defense mechanism to you feeling either attacked or feeling that somebody is out to get you or out to harm you in some way. A lot of times when it comes to retaliation, a lot of people think of, for example, employment discrimination, of saying, well, I filed this complaint, then they fired me. It can absolutely happen in housing too. 10 of those cases that we had from the last biennium were related to retaliation. And so it certainly is something that we see frequently occurring. And it's oftentimes either in response, for example, to requesting a reasonable accommodation, or maybe they filed with our department or with HUD, and as a response, the respondent has taken some sort of retaliatory action, or that they're just being alleged to have taken some sort of retaliatory action. So why would somebody retaliate if they knew that it was against the law? Again, oftentimes it's a defense mechanism. It's something that if they feel slighted because either something that was said or done they don't believe was true, or again, if they are kind of making, I would say, a lot of burden for somebody. If they felt, hey, this person is just poking my buttons. They're sending me all these requests. They're, sending me all these documents. They're filing with these departments. They are just out to bother me. The natural reaction may be to try to kind of get back at that person. It's oftentimes when any individual either files against a respondent or against a specific individual or is making these kind of allegations, a lot of times the other party, of course, would think that there is some sort of malicious intent behind it. And then their natural inclination is to defend themselves. When it comes to retaliation, one of the big things is we obviously look at whether or not the individual had participated, or basically whether they had requested reasonable accommodation, if they had made some sort of either complaint of discrimination, whether it be to the respondent or to our agency or a different agency, and did whatever following action occur because of those original actions. So, for example, let's say the individual requested a reasonable accommodation, and after they requested a reasonable accommodation, they were issued an eviction notice, and they said, I felt like it was because I had requested this reasonable accommodation. If the evidence can prove that yes, the reason that they had been evicted was because they had filed this complaint, or they had requested this reasonable accommodation, it could be a violation under the retaliation statute. So in housing, that's oftentimes something that we may see with relation to retaliation. One thing that is happening quite frequently, kind of, I guess, an up and coming potential change that may happen in the future, background checks have always been kind of on the horizon in general with HUD. One of the big things that when it comes to background checks, they are absolutely legal for a housing provider to ask questions about an applicant's background. As we walked through those protected categories, a criminal background is not something that is a protected category. But one thing that HUD really looks at when it comes to any sort of discriminatory actions related to criminal backgrounds is what we have disparate treatment and disparate impact. So disparate treatment would be if the individual is specifically being treated differently. So I am discriminating against you based on XYZ. Whereas disparate impact is actually whatever your process or policy is, it's neutral on its face. It's the whole intention, for example, on having some sort of criminal background check is to ensure that you are screening applicants, that you're making sure that the housing facilities are safe, but they may have an adverse impact on a specific protected class just by default. By the fact that they're existing, they may be causing a discriminatory kind of ripple effect. One way to look at it, and this is just a breakdown of the prison population, specifically for North Dakota and for the United States. And when you look at the kind of percentages of people in prison of certain races and then in the general population, there can be kind of a skewed number of the amount of individuals who may have a criminal background that are of certain races, and that's where that disparate impact comes in. Again, I just bring it up because it is something that I just went to a HUD conference a couple of weeks ago, and it was something that was very thoroughly talked about. I would not be surprised if in the next coming years it's talked more about, specifically in relation to either being added as a protected category or having additional guidance on how criminal background checks are used or viewed. But it's just something kind of to keep in mind, to think of that in the upcoming years, it certainly may be a change that's coming down the line. Other issues we deal with, publications. When it comes to publications, what the law states is that a person may not make, print, or publish, or affect the making, printing, or publishing of a notice, statement, or advertisement that's about the sale or rental of a dwelling that indicates any preference, limitation, or discrimination because of the person's membership in a protected category. This obviously, when we think of making, printing, or publishing, oftentimes, at least maybe I just think of it as newspapers. This is much more broad now. Obviously, with the kind of coming of times of social media, it could be in text messages, memos, it can just be, again, in statements that are made as far as indicating, again, some sort of preference or limitation based on that person's membership in a protected category. Again, when we think of what those examples are, publishings in newspapers or other media, so if it's an advertisement for the property itself, it could be any written statements, verbal or nonverbal statements. It's not always going to be ill-intentioned, but if it shows some sort of preference or limitation, that's where it's going to be problematic. So if it's indicating, we don't rent to individuals who receive rental assistance, or we do not rent to single bachelors, those can show a preference or a limitation based on a protected class. And it may not necessarily always be ill-intentioned. They might be well-intentioned. Let's say, hey, I have dealt with this issue so many times in the past. I'm done with it. I'm not going to rent to families anymore. There's been too many problems in the past, so I'm just going to make sure that it's clean going forward. Again, that shows a preference or a limitation based on a protected category. So even if it's well-intentioned, it might not necessarily be legal. Again, there's still some of those exceptions for the publications as well. Same type of thing. It could be housing for older persons, again, kind of indicating preferences or limitations, those private clubs or religious organizations, and some shared living housing. So if it's, for example, like an all-girls dorm, that's obviously showing a preference, but it can be exempt from those publication laws. And when we're looking at these, it's going to be based on what, again, that reasonable person standard. So we've talked a little bit about what's reasonable and what's not, but when it comes to what these publications on whether or not we're determining if they are discriminatory or not, big thing we're looking at is it going to be readily apparent to just an ordinary reader or listener that they are indicating some sort of preference? Like I said, if they're saying, no, at this time, we're not renting to anyone with rental assistance, that is showing a preference or a limitation saying, no, you cannot rent here due to your receipt of public assistance. That could be a discriminatory statement. No, we prefer maybe tenants that have families just because of the way that the neighborhood is. That could be a limitation saying, well, we don't want any single individuals here. So anything that is just readily apparent to an ordinary listener or reader is really what we're going to be looking at when we determine if that's a reasonable statement or if it's discriminatory. Again, there's just kind of a variety of terms to avoid. I would say, certainly in the time and era when you kind of explain what the unit is, I feel like a lot of people have gotten certainly better about how they maybe list units and really talking a lot more about what the property is versus what the type of tenant they want. But again, during just general conversations, statements, memos, things like that, just making sure to avoid certain topics or subjects. Again, biggest thing you're looking at here is making sure you're not indicating some kind of preference or kind of basically anything that may be perceived as discriminatory based on a protected category. So obviously, a lot of these terms, they seem so outward and obvious that of course nobody would use some of these. Nobody's going to say no older persons apply. But you want to always be aware that it's not always just going to be in the general, I put a listing out there saying these are the things that I do or don't want in there. It can be those just emotionally charged conversations. Again, one thing that, and you'll hear it as I kind of go through these, but going through training with your employees is going to be a big thing. It's easy for individuals to think, I have to be professional, I'm at work. But these situations sometimes can be completely emotionally charged. They can be very upsetting. And so having kind of those outward outbursts can be problematic depending on what you say. So being aware that these terms should be avoided, being aware that there are laws that indicate if you're doing something that shows some sort of preference or discriminatory action, that can be illegal. So truly training and knowledge and awareness, I think, is the easiest way to prevent some of these in a time and era right now where everything is so easily accessible to recordings, to saving, for example, text messages, Snapchat, Facebook messages, all of those things, even if they were kind of said in context or in the heat of the moment, they can be certainly problematic. So being very mindful of what is said, and any of the individuals that do interact with the public, making sure that they're aware that these things do exist and they can become problematic, I think is the best way to hopefully combat it a little bit. Again, rule of thumb, generally speaking, when you're advertising for a property itself, describe the property, not the person you want living there. So if you're notified a complaint is filed with the department, now what? Most people panic. It's unfortunately just kind of the lay of the land. Unfortunately, if an individual believes that they have been discriminated against, as long as they file and it falls within our jurisdiction, we can open the complaint and basically move forward with the process. You can be the nicest landlord in the world and a complaint still may be filed against you. It's nothing against you personally necessarily. It's just kind of the way of business, unfortunately. But what happens once we have a complaint file? So when we receive the initial kind of step, the first step in the process is we receive an intake. This intake is basically allegations from the complainant saying, I believe I was discriminated against and this is what happened. This is how, these are the dates. They just explain a little bit of what the situation is. The next thing that happens is one of our investigators receives that complaint and we determine whether or not we have jurisdiction to proceed forward. So some of the things that we look at when we're looking at jurisdiction, the statute of limitations for a housing complaint is 1 year from the date the complaint is filed. So if the individual files with us and says 6 years ago, XYZ landlord discriminated against me, that's going to fall outside our jurisdiction. If they haven't lived there in 5 years, there's no way we have any sort of authority to move forward with the complaint, then it's not going to be able to be filed with us. So that's one of the things we look at jurisdictionally. We look at whether or not they're alleging some sort of discriminatory conduct. So are they alleging discrimination based on one of those protected categories? If so, then we may have jurisdiction to proceed forward. Does the respondent right on the outset have no authority to be able to move forward? So let's say it was, for whatever reason, not a sale or rental situation or a situation that even falls under the realm of housing. We may not have jurisdiction under that realm. If we do determine we have jurisdiction, so the allegations, if true, may constitute a violation of the law, it's filed within the statute of limitations, then what we do is we take what those allegations are and basically write a summary of those allegations and put them in our formal complaint form. So the formal complaint form, it always indicates who the respondents are, who the complainant is, where the alleged discriminatory action occurred, what is being alleged as far as protected categories. So whether that be disability, race, religion, whatever the protected category is, it explains what they're alleging occurred, and then gives a short summary of what those allegations are. Once we have that kind of summary put together, we send that to the complainant. The complainant reviews it. If everything's accurate and correct, they sign it and they send it back to us. When we receive that signed complaint, so the signed summary that we sent them, once we receive that signed complaint back, then the case is officially opened with our department. And at that point, we send the complaint on to the respondent or respondents for a response. So we basically, it's kind of we receive the allegations, then we send out to the respondent saying, all right, this is what's being alleged. What's your side of things? What occurred in your opinion? What are the facts and evidence that you have to support your position? That's all the information that we're looking for with the response from the respondent. And then once we receive that response back, that's when we investigate the allegations. So we determine whether or not a violation of the law occurred or not. And once we determine that, then that's when we issue out a determination. So the determination, all it is a written report of our findings. So it explains the kind of all the allegations, explains whether or not we believe the violation of the law occurred or not, and how we got to that point. One thing that is emphasized throughout the process is conciliation. So conciliation is just informal negotiations between the parties. Basically, it's trying to come to a resolution before the point of going through the entirety of the investigation. So before the department issues out a determination, it's a way for the parties to kind of come together to a resolution without having to complete that process. The conciliation process is confidential. Either party can certainly have representation throughout. So if the complainant wants to have an attorney, if the respondent wants to have an attorney, they certainly can have that. They're voluntary. So at any point, if either party says, you know what, I'd just rather go through with the investigation, they can certainly do so. Whenever we receive any sort of conciliation offer, we take that offer and relay it to the other party. The other party then has the opportunity to accept the offer, decline the offer, or provide a counter offer. So whenever it comes to any sort of resolutions, basically it's both parties have to absolutely agree to the final terms of it before it can actually be executed. The agreements themselves, they basically, if the parties agree to the terms, we put them together in a formal agreement through the department. We send that out to the parties, and as soon as we receive those signed agreements back, then that is a formal binding agreement. And we monitor the progress of those. So if there's any terms that, let's say, if the respondent says that they're going to participate in trainings going forward, they would sign off on that, and then they would provide us documentation going forward that, see, these are the trainings we did provide. So they are monitored by the department. One thing to keep in mind with conciliation is there's kind of two parts to it. There's always relief for the complainant. So whether that be, it could be a positive or a neutral reference, it could be granting a reasonable accommodation, it could be some sort of monetary amount, it could be being released from their lease, things like that. Those could all be resolutions that would benefit the complainant. Additionally, there's always a part it's called relief in the public interest, and that's going to be some sort of portion of the agreement, basically that's saying we as the respondent agree to ensure fair housing is kind of continuing forward, that we know the fair housing laws, that we are willing to make sure that there aren't any sort of fair housing issues going forward. And those can be all sorts of things, whether it be reviewing, for example, HUD's guidance on service or assistance animals. It could be participating on taking a fair housing training in the next 6 months or the next year. It could be updating their policy. It could be really any of those things, but it's something that's going to provide some sort of benefit to the general public, not just the complainant themselves. So those two pieces are always going to be part of a conciliation agreement. If conciliation is not successful, or if the parties don't participate in that, we continue forward with that investigation, and then ultimately we issue out a determination. So we either determine that based on the facts and evidence, a violation of the law did occur, in which case, if we do believe a violation of the law occurred, then we issue what we call a charge out to the parties. And it's just a short and plain statement of the facts on which the department is basing its cause finding on. So it's basically explaining how or why we believe that a violation of the law did occur. And if we believe that based on the facts and evidence, no violation of the law occurred, then we dismiss the complaint. But again, we issue out that determination or that written report of our findings explaining how we came to that conclusion. During the process, this is a question we get frequently. The department is a neutral party. So we are not on the complainant's behalf. We're not on the respondent's behalf. All we do is take the facts and evidence and determine if a violation of the law occurred. We conduct fair, impartial, and thorough investigations. Again, all we're doing is determining, based on the facts and evidence, is there evidence to determine that a violation did or did not occur? All of the investigators, whether again for employment discrimination, wage and hour, we're always acting as that neutral party. For better or worse, we're always the middleman that someone is upset with, because there's always, whether we find in the favor of the complainant or find in the favor of the respondent, oftentimes someone usually is disappointed in the outcome. But regardless, the department really, for best terminology, we basically act as lawyers throughout and have very thorough investigations. All we're doing is looking at what the facts and evidence is and compare it to the law. And so that's really solely what our department is there for. That's what our process is. And so when a complaint is filed, those are kind of the things to expect going forward. The department, any of the investigators, our administrative staff, we're very, open. If there's questions about the law, we can't provide any sort of legal advice or guidance, but we certainly try to point to anybody in the direction of the law that might pertain, or certainly give them any sort of information to help get some further education on some of these issues. So how do you know what not to do? Get educated. That's obviously the easiest one. Being at things like this, just having a better knowledge of what occurs throughout the process and what expectations there are and aren't. Just even having it kind of sit in the back of your head when these issues or situations come up, it will flag you to either look a little bit deeper into the issues or reach out to contact whether it be an attorney or a fair housing organization to understand the law a little bit better. Our website, obviously, we have some brochures. We have the law itself on the state side of things, and HUD's website, I would say of many government websites, it has some really good question and answer kind of laid out fact sheets and information that provide some great guidance as to how to look at some of these situations. And they oftentimes are changing it and updating it. So it's a really great resource just to get a better knowledge about what some of these laws are. But if you are not sure about it, make sure you talk to an attorney that is knowledgeable in fair housing laws. You may have a spectacular attorney at tax law, you may have a wonderful divorce attorney, but you'll want to make sure that you're talking to somebody who is knowledgeable or has some dealings with the fair housing laws, because it can be a very, quite a web to try to get through all the information. And so if you have somebody who has a good knowledge base of that, it's going to be exponentially helpful for you. Best things I can recommend specifically as an investigator is document everything. In the day and age, again, of having everything easily documented, text messages, emails, recordings, anything, just make sure you keep good documentation. My job would be a billion times easier if everyone just really kept good documentation. And I get life can get overwhelming. Sometimes things crash, sometimes things die. We do understand that, but when it comes to kind of proving your case, a lot of it's going to come down to the evidence that is provided by both sides. And that's if the complainant is stating one thing, it's always nice to be able to have the documentation to back it up on the other side, just to support kind of where you're coming from as well. Avoid sudden rash decisions. When it comes to requests, for example, if you have, let's say, a phone call or an email asking what seems to you be a ridiculous request, don't have those sudden and rash decisions or statements. Those can be problematic. We talked a little bit about there's testing things, there's, there are expectations of you to provide responses and kind of work through that process of reasonable accommodations. So the instant and sudden no sometimes can be problematic. So just kind of stop and think a little bit before really jumping into some of those further responses or decisions on to whether or not you're going to either grant accommodation requests or how you're going to handle certain situations. Train your managers and staff, especially those that are dealing directly with the public. Even if you, let's say, have a wonderful office staff that is thoroughly trained, if you all leave the office for the afternoon for lunch and the one person that is there that doesn't have any sort of training on any of these things, what that individual says can be problematic if it is discriminatory. So making sure anybody who's going to be dealing with the public, again, at least has a general knowledge of some of these things. It's not that they necessarily have to go through an intense training course on it, but making sure that they have an awareness and have a knowledge base that some of these things that are done or said can be problematic, or how to direct those to other individuals might be helpful in the long run for preventing some of these issues. Know the law. Again, it sounds a little bit kind of ridiculous, but just having an ignorance to what the law was doesn't help. If anybody has ever been pulled over for speeding and said that they didn't know that it was 25, an officer does not generally care. And it's not that we don't care, our department cares quite a great deal, but when it comes to violations of the law, just a lack of knowledge of the law is not going to be a defense that's going to be permissible. If you're not sure what the law is, if it doesn't make sense and you can't quite figure it out, contact an attorney with experience in the area, and it certainly will help you. Be consistent, making sure you are not showing preferences in certain ways. And really, as tough as it is, because a lot of times North Dakota Nice is an absolute real thing and people are trying to help somebody else out, but sometimes it can be problematic. So trying to be consistent and have certain expectations, it just really will help you, and certain policies or practices that you go through when it handles some of these situations will be helpful to you. And then lastly, be nice and communicate. I can tell you every one of our investigators would absolutely agree. We do not deal with a ton of people that are thrilled with whatever the situation was, but they just feel like they have to file because they're just not sure if it was following the law. We don't usually deal with a whole lot of really happy, excited people about whatever the situation was that had occurred. Working with people, again, it's not going to prevent every case from being filed. It certainly is not. And you may still have cases that are filed against you, even if you're the nicest person in the world. But working with your tenants and actually trying to come to resolutions not only will help you by having happier tenants, not having some of these kind of turbulent situations, but it also helps them. And having clear and concise explanations and guidance to why decisions are made the way that they are, or what you're requesting from people, it helps them as well to have an understanding of what's being expected of them. Communicating some of these reasons certainly will help this kind of entanglement when it comes to some of these issues. Won't prevent all of them, but it certainly can help. So with that, that's all I have. I am assuming I may have some questions. Like I said, the department, we can't provide any sort of legal advice, guidance, anything like that, but we certainly are. We try to be very helpful. We're very nice people. And so if you do have questions, whether it be right here during the training or after the fact, if you're going home tonight and you're thinking about my riveting presentation and you really wanted to ask additional questions, reach out to us. You know, whether or not we can actually give you a yes or no answer is to be determined depending on what your question is, but we certainly try to point you in the right direction on getting some additional information.
There is one question. Sorry, my kids just got home from school, so if you can hear them in the background, I apologize. Is it possible for the service provider owner to ask that parents supervise their children or ensure they are with another trusted guardian? Is that targeting a protected class by requesting that? For example, the lack of supervision is bringing about significant damages to common areas of the building. The goal is to never restrict any access, but rather make sure that everyone is safe and taking care of these shared spaces.
That's one of those that is hard because it's not necessarily a yes or no. It's really going to be dependent on the situation. Certainly, it could demonstrate some sort of preference based on a protected category. But again, kind of similar to the discussions I had regarding the reasonable accommodation and having expectations and rules, you know, just because it's an tenant that has a family does not mean it's completely exempted from rules and regulations. But one of those, if you're going to draft up anything, that's definitely something I would reach out to an attorney just to double check the way that you're kind of wording it and applying it and making sure that it isn't demonstrating a specific preference based solely on individuals with children.
There was one earlier about, are you able to send out your presentation?
Yes, I actually, I had put it together in a PDF and I have it in my email to send you and I just never hit send. So I will send it to you, Kylie, after the presentation. You can send it out.
Perfect. Sounds great. With that, it doesn't appear to be any more questions. So thank you again for presenting today, and thank you everyone for joining. Just one last thing, just remember to, if you need a certificate of participation, please email Stacey and she'll get that out to you. And then please respond to the survey that will also be sent out to you. Just takes a couple minutes, and any feedback and possible topics are greatly appreciated. So thank you again, and hope everyone has a great rest of the day.
Thanks, guys.